Welcome to Employment Law This Week. I'm George Whipple. Non-compete litigation looks different when a physician is involved. The decision to take the matter to court is not always clear. In this week's episode of Spilling Secrets, Epstein Becker Green's podcast series about trade secrets and non-compete law, the panel discusses the unique challenges involved in litigating physician non-competes. There is no ethical rule barring non-competes for physicians. But Epstein Becker Green's Erik Weibust tells us that courts tend to treat physician non-compete litigation differently than other non-compete cases, especially when the employer is asking for an injunction.
One of the factors in many states for obtaining an injunction is that court has to consider the public policy. And of course, one of the elements of enforceability of any non-compete is that it has to be reasonable in scope. With all of that in mind, when you go to the court and ask for an injunction and the person you're trying to stop from working, or at least stop from working in a particular area, is a physician or a nurse or some other frontline healthcare worker, all of these factors come into play.
Epstein Becker Green's Dan Fahey tells us more about the unique issues surrounding physician non-compete litigation.
There's a lot of public policy around patient needs, so there's definitely reputational harm if you're going to be pursuing a physician for violating a non-compete agreement. I think the other piece of it is somewhat the investment. If there's been a significant investment in a specialty or building up a team around them, there may be more incentive that this person really spurned us.
There is a lot for healthcare employers to consider when making the decision whether to litigate non-compete violations. Epstein Becker Green's Jill Bigler offers several questions employers should review before going to court.
First and foremost, we want to take a look at what's the legitimate business interest that we're trying to protect here. How likely are we going to be able to enforce this agreement? Courts are more likely to enforce a non-compete if there's confidential information or trade secrets that have been taken. As Dan alluded to, what's the investment here? Have we provided that provider with significant training or access to a patient base? Those are all things that maybe would cause us to want to enforce that agreement in that situation. But again, on top of what's the legitimate business interest, we also want to take a look at what's the harm, potential harm to the employee, what's the potential harm to the public.
The team digs into more considerations for litigating physician non-competes on the latest episode of the Spilling Secrets podcast. Subscribe to the Employment Law This Week feed wherever you get your podcasts to hear the full audio episode and to catch all future editions in the Spilling Secrets series. Thank you very much for watching, and we'll see you next time.